Hi, this is Dr. Perry Carpenter. I'd like to thank you for taking the time to join me on this week's video. In this week's video, we're in session number 7 of our ongoing series of discussions related to the new medical legal fee schedule. And today's discussion is being recorded almost 60 days after the effective implementation date of the new medical legal fee schedule. So I'm coming to you today to share with you some of what we've learned over the past 60 days. Now, over the past 60 days, several things have happened, including the fact that we've begun to bill and receive payments. We're now receiving payments under the new medical legal fee schedule. And in addition to what's happening on our side, meaning on the QME side of the new medical legal fee schedule and all the issues related to the QMEs use of the new medical legal fee schedule, the other parties involved in the system, such as applicant attorneys, such as defense attorneys, and such as the claims payers, have now mostly fully come on board with the new medical legal fee schedule. And I want to share with you in today's discussion some of how these other parties are perceiving and are using the new medical legal fee schedule to their benefit, to their advantage, and to exercise their incentives under the new medical legal fee schedule. So we've learned a lot over the course of the past 60 days, some of which I want to share with you in today's discussion. Now, before we get into the topics of today's discussion, let's just briefly review some of the overriding philosophy of the new medical legal fee schedule and where we've come from so far in this program. In session number 1 of this program, we talked about the effective implementation date of April 1st, 2021, and I shared with you some of the sequences of events and some of the history behind the need for the new medical legal fee schedule. And I brought to you a unique perspective. I kind of brought you into the room of the fee schedule committee meetings, where I was fortunate enough to be able to participate in 2 of the 4 fee schedule committee meetings. I was present at the last 2 out of 4 fee schedule committee meetings, and I shared with you some of the parties' concerns that led to the development of the new medical legal fee schedule as we know it to be today. Then in sessions number 2 and 4, both of which, or all of which, sessions 2, 3, and 4, all of which were recorded prior to April 1st, 2021, we started to review and analyze the new medical legal billing codes. And we compared and contrasted the old codes with the new codes. And I shared with you several case examples as to how the new codes are going to be used in both your face-to-face evaluations and in billing for your supplemental reports using those new codes. Then session 5 came along, and by the time we were into session 5, we were just at the effective implementation date of the new medical legal fee schedule. And that brought us to the point in time where we started to be scheduling appointments into the future into cases that would be billed under the new medical legal fee schedule. So as we began to schedule those cases and as we began to consider how those cases were going to be mechanically evaluated, we started to see that the new medical legal fee schedule changed everything about how we constructed our face-to-face interaction with the examinee and how the new medical legal fee schedule changed the entire structure of our final product, which is our QME report. So I shared with you some of the new insights as to how you could go about constructing your very next face-to-face evaluation. And that was a fascinating revelation as we were on the brink of the implementation of the new medical legal fee schedule. Well, about 2 weeks after that, I came to you in session number 6, now with the new medical legal fee schedule well underway, now with cases being evaluated, under the new medical legal fee schedule and with cases being billed under the new medical legal fee schedule. And as we began to bill for these evaluations, several additional new insights were gathered and accumulated as to how the new medical legal fee schedule really dictated how we as qualified medical evaluators could best use our time, best use our efforts, best use our energies, and best use our resources in order to remain profitable under the new fixed and flat rate fee structure of the new medical legal fee schedule. I'm going to share with you some more ideas in that regard today. So the take-home message of session number 6 was that except in cases that involve large volumes of medical records for which the case value of each of our evaluations begins to escalate, except for those scenarios, all of the billing levels under the new medical legal fee schedule, except for deposition testimony, involve fixed and flat rate fees. Well, if that's true, and if it's true that time-based billing codes are now obsolete, it's essential now more than ever that we as qualified medical evaluators become extremely efficient, extremely time efficient in every single procedure that we do, from the inception of the first intake phone call all the way to dropping the report in the mail at the post office. Every step and every step in between has to be extremely time efficient. Otherwise, the doctor's hourly rate plunges below the intended rate that the DWC is intending for us as qualified medical evaluators to be able to capture, which is approximately, give or take, $325 per hour. And I shared with you in this session how to maintain, sustain, and retain your hourly rate. And that brings us to today's session. Today's session is being recorded approximately 60 days after the effective implementation date of the new medical legal fee schedule. And by now, all parties are well underway in the new system. And I want to share with you some additional ideas that we are discovering as we accumulate more and more cases under the new medical legal fee schedule, and as patterns start to demonstrate themselves as to how these evaluations should unfold in order to satisfy all of the parties involved in the system. And I have several ideas to share with you today. Okay, so this will be our final discussion in this series of discussions on the new medical legal fee schedule. So let's begin today's discussion for you specifically as a qualified medical evaluator and your secrets of success under the new medical legal fee schedule. Okay, so let's begin with QME secrets of success under the new medical legal fee schedule. Now, the overriding principle under the new medical legal fee schedule is that time is of the essence. And the reason that time is of the essence is because time-based billing codes under the former medical legal fee schedule are now gone. Now, except for deposition testimony, all of the fees provided under the new medical legal fee schedule are fixed. They're flat rate fees, regardless of how much time you invest in the evaluation. Now, each of the flat rate and fixed billing codes have a anticipated or a projected number of hours that you as the evaluator are expected to devote and dedicate to the evaluation. In other words, the Division of Workers' Compensation, in their infinite wisdom, has estimated an approximate number of hours that each of these levels of service should occupy in your life as the qualified medical evaluator. Now, you have an option to either exceed, meet, or extend those projected time frames projected by the Division of Workers' Compensation. If you meet the time frames, then you meet what the Division of Workers' Compensation expects for you to be paid for each of those levels of service, which is approximately $325 per hour. If you extend the time periods, which you have every prerogative to do that, you have the authority to do that. If you extend the time parameters, then your hourly rate will dip below that which is intended for you by the Division of Workers' Compensation. So how much time you devote and dedicate to every evaluation is entirely up to you, but in order to remain profitable, time in all procedures is of the essence. You have no time to, certainly no time to waste, no time to squander, no time to fritter away, because you cannot be billed, you cannot be paid based on your time. Under the former medical legal fee schedule, we had time-based billing codes, and we could invest all the time necessary to produce a finished product that was a masterpiece in our own opinions. Okay, so those days are gone, so time is of the essence. Well, if time is of the essence, and if you agree with this concept, then it's more important now than ever that you get the big picture, that you step back and get the bird's eye view picture of each and every evaluation that you're involved in. It's sort of like flying in an airplane at 50,000 feet, looking down over the big picture of the landscape below. You know, as you walk the landscape below from ground level, you can become distracted by the trees and not see that there's a forest bordering the trees, that the trees are part of a larger picture called the forest, where you can see the forest from 50,000 feet in an airplane above, but many times at ground level we get distracted by the minutia of these cases. So it's important that you step back and ask yourself what's happening with each and every evaluation, and I'll give you some ideas on that as we go. Now, in terms of getting the big picture, let's go all the way back to the inception of each and every case. And each and every case begins with you with a phone call to your office from one or the other of the parties requesting an evaluation from you. So this is where your admin even prior to the face-to-face evaluation is critical, because your admin costs are contained and subsumed within the fee, the flat rate fee that you're going to be reimbursed for each and every evaluation. So it's necessary, it's critical, it's essential that you minimize your admin costs because admin costs detract from the time that you can dedicate to the evaluation. The lower and lesser that your admin costs are, the more time that you can devote to the evaluation. So it's essential that you reduce your admin costs. This is what we're learning under the new medical legal fee schedule. So I have some ideas for you to help you reduce your admin costs. Okay? Now, when the first phone call comes in for you for a qualified medical evaluation, let's say you receive a call from the applicant attorney. Now more than ever, it's important that you get a copy that you request the party send to you, a copy of the panel request. This is the form that the parties use to request the QME panel, the panel upon which your name showed up, for which you've been left the last man standing, and now that you're receiving a phone call for the evaluation. You need to get a copy of that panel request. And the parties have this paperwork. They have it available in their file. They will provide this to you if you'll simply ask for it. The reason you want to ask for it is because this form many times contains demographic information that the parties won't send you, or that when the parties do send you the demographic information that they have, the demographic information that they have is not complete. And some of the missing pieces of demographic information you can obtain from the copy of the panel request. This will save you tremendous time when it comes time for you to fill out your appointment notification form. When you fill out that form and you find that you have missing information. When you have missing information in the absence of this piece of paperwork, You then have to get on the horn and call up the applicant attorney and request the missing information. You have to send an email. In other words, time, you start chewing up time simply to obtain information necessary to fill out the appointment notification form, and your profitability on the case dwindles with each piece of missing information. So much of the information is contained within the panel request. This is the request that's sent to the DWC, so it has to include complete information. So that will help you. Number two, the panel request will tell you the labor code under which your evaluation is being ordered. Now, there's 3 labor codes, 4060, 4061, and 4062, under which each of these evaluations is ordered. And each of these labor codes defines a different dispute for which you're being called in to resolve. Now, if you can determine the labor code, which is contained on the copy of this panel request form, if you can determine the labor code that's driving the need for your evaluation, that tells you exactly, and it tells you everything that you need to do in the face-to-face evaluation, and it tells you exactly and everything that your report needs to resolve in order to resolve the disputed issues to satisfy the parties. So if you can target and pinpoint the disputed issue, you can go directly to it and disregard all of the other peripheral, irrelevant, and unrelated issues. You can focus your evaluation and be extremely time efficient if you can determine all of this in advance. It's critical that you determine this in advance, the opposite of which is in arrears. And when you're in arrears, you're going to be losing profitability. The next procedure that I'm going to suggest to you is that you demand, not just ask, demand copies of the strike letters that have left you as the last man standing. Now, many times you'll get a call for a qualified medical evaluation. Typically it'll come in from, say, the applicant attorney, or it can even come in from the defense attorney, or even from the claims administrator, and you will be advised that you're the last man standing. But a request for an appointment, a phone call for an appointment, is not the same as a bona fide, verified, compensable appointment. Sometimes, even though you've been advised that you're the last man standing, one or more of the other parties may have a dispute over any collection of concerns, such as the specialty of the panel, such as they never received the panel and never had their opportunity to strike a doctor from the panel, such as they're unaware that there's even a claim. In other words, there's a whole plethora of disputed issues that could arise, even though there is a bona fide panel, even though there is one party requesting you as the qualified medical evaluator. It's important that you ascertain in advance, before you invest time, effort, energy, staff resources into setting up this appointment, which in some cases can take hours, okay? It can take hours when done properly. Before you invest any of those resources, that you're indeed the last man standing, and none of the parties have any objection to moving forward with you as a qualified medical evaluator. Now, let me give you an example. Let's say you get a call for an appointment from an applicant attorney, and they send you a copy of the panel, and they send you the demographics, and you set up the appointment. You set it up. Your staff types it up. She notices all the parties. She sends out letters in the mail. She devotes 60 minutes to this administrative procedure, only to learn 2 weeks later that the other party is objecting to you as the qualified medical evaluator. They say something like, we never had the opportunity, we never received a copy of the panel, we didn't know that there was a panel, we didn't know that we had an opportunity to strike, and we're objecting to the panel. And this happens all the time. It happens all the time because these applicant and defense attorneys are in an adversarial, litigious relationship with each other, and they're always strategizing, and sometimes you as the qualified medical evaluator can be the piece of the strategy that one or the other parties moves around in an effort to leverage the other party. Well, don't let yourself get into such a scenario. Don't let yourself waste your staff resources and your profitability unless there's no dispute that you indeed are the last man standing and that the parties have no objection to you moving forward as the qualified medical evaluator. So when you get the intake call, ask the parties to send you a copy of the panel request form, copy of the demographics regarding the examinee, copy of the panel, and copies of the strike letters. Now the parties, they're gonna sometimes be chagrined by this, and this is going to involve extra work on their end, which is going to increase their staff time. But these are documents that they all have available in the file, and they simply just need to take the minute it takes to attach them in an email to you. And once you secure all of these documents, then you can proceed with scheduling the evaluation, knowing that your staff and admin time is not going to be wasted. Okay? And then finally, now more than ever, it's critical that you obtain email addresses from all parties, from legal secretaries at the applicant attorney's office, same at the defense attorney's office, that you get the claims administrator's email address, because in this new era, in this now becoming post-COVID era, people don't answer their phones. Many times they're still working from home. You're always going to get a voicemail message, and this is just churning and burning and wasting time. The most direct method of communication nowadays is by way of email. These parties typically will respond by email. So it's essential that you obtain email addresses, because email addresses are portable, whereas office phone numbers many times are not portable. So these people that are working from home, they receive their email at home and they can respond to your need and concern. And it's a tremendous, tremendous time saver to communicate nowadays by way of email. And in addition, email addresses and email communications provide you a paper trail with which it makes it easy to follow up and track your communications with the parties. Okay? So these are a couple of ideas that will help you remain profitable in reducing the amount of administration time involved with each new case and the intake of each new case. Okay, so now let me share with you some ideas regarding the evaluation itself. Okay, so now regarding the evaluation itself, again, time is of the essence. And if that's true, it's more important now than ever that you step back and get a bird's eye view of the big picture of the evaluation. Now, in stepping back and getting the big picture of the evaluation, what you want to focus on is you want to focus on what is the recurring theme in this evaluation. What is the recurring theme? So that raises the concept of recurring themes. Are there themes that recur over and over and over again in these evaluations that you're called upon to evaluate? Well, that's an interesting concept, and what I've found in consulting with qualified medical evaluators is that when qualified medical evaluators have a few number of evaluations under their belt or in their career, say less than about 300 or 350 to 500, a small number of evaluations under their belt, it seems that every single case is a unique four-leaf clover. It's like a snowflake. No two snowflakes are the same, and qualified medical evaluators get bogged down into the minutia of the details of every single case. But after, at some point, after a certain volume of cases under your belt, and for each qualified medical evaluator it's different. It could be the 300th evaluation, it could be the 500th evaluation, but at some point you'll realize that, you know, you've got to step back and look at the big picture of the evaluation. And if that's true, it's more important now than ever that you step back and get a bird's eye view of the big picture of the evaluation. Now, in stepping back and getting the big picture of the evaluation, what you want to focus on is you want to focus on what is the recurring theme in this evaluation. What is the recurring theme? So that raises the concept of recurring themes. Okay, so now regarding the evaluation itself, again, time is of the essence. And if that's true, it's more important now than ever that you step back and get a bird's eye view of the big picture of the evaluation. you've seen this case before. You'll be sitting face to face with an examinee, and the examinee will be telling you the history of their industrial injury, and you'll have a revelation, boom, and the light bulb will go on, and you'll realize, even though the examinee is different, has a different name, a different face, you've heard this story before. Some synapse will go off in your long-term memory bank that you've heard this case before, and you realize that this case is a very similar scenario to another case that you had some time ago in the past, and there's a theme that's recurring between the two cases. Well, as you continue to evaluate cases, and as you continue to become more expert in the AMA guides, and as you continue to review case law, in other words, cases that are settling out there in the community, as you become exposed to more and more cases, you realize that even though there's an infinite number of examinees, the cases and the scenarios and the situations that they present to us as qualified medical evaluators with, is very, very finite. There's a small series of themes that recur through each of these evaluations, and I'll give you just a small list. This isn't a complete list. There's about a dozen themes that recur through these evaluations. Here's just a couple. Number one, is this a denied claim? If this is a denied claim, this is something you want to ask yourself in each and every case. Is the theme operative in this evaluation that of a denied claim? If it's a denied claims have a very exact and specific handling, and if you can spot that as the recurring theme, you can get right to it and resolve that quickly, efficiently, and profitably in your evaluation. I'll give you an example. Yesterday I was consulting with a qualified medical evaluator who has a deposition today. So I was consulting with him yesterday to help him prepare for his deposition, and I spotted right away that the claim was denied. And the reason that the claim was denied was because that the claim was being filed post-employment. This is an employee who was laid off during the COVID crisis and then filed a claim in the post-employment period. So I spotted this. He had, of course, no idea about this. And so as we got into the details of the claim, I realized that the employee was trying to exploit or capture exception number 3, exception C, under Labor Code 3600 Section 10, which describes 4 exceptions to the post-employment bar. I realized that the examinee was trying to capture exception number 3, exception C. So this qualified medical evaluator and I pulled up Labor Code Section 3600. We reviewed the laws regarding the post-employment filing of claims, and we could see exactly what was operative in this case, and that told us exactly how to proceed in the deposition. So if you can spot the recurring theme, and the more familiar you become with workers' compensation in totality, the more you'll realize that there's only a finite number of themes, and once you can master those themes, you can quickly get to the business at hand. Some other themes involve multiple dates of injury. Those have a specific and exact handling. Sometimes multiple dates of injury involve multiple insurers, and so those have an exact handling. Cases that involve multiple body parts, some as specific injuries, some as cumulative trauma injuries, some as compensable consequence injuries. If you can identify and spot these recurring themes in these evaluations, you can get right to the task of evaluating those disputed issues and resolving those disputed issues very, very quickly. And it just depends and is based on you being able to spot the recurring theme in advance. So when you get an evaluation, step back, take a look. Take a look at the date of injury. Is it a recent date of injury? If it's a recent date of injury, it's most likely that the dispute involves compensability, AOE, COE, in which case possibly it's a denied claim. Is the date of injury somewhat remote, maybe 12 months ago? 18 months ago. If that's the case, it's likely that the examinee has an accepted claim, the examinee's gone through medical treatment, and they're now coming to you for a different type of dispute resolution. And so you can determine these disputed issues simply by stepping back and spotting the recurring theme. Now, in terms of getting the big picture, it's critical that you redirect much of the time that you used to devote in your evaluation to your face-to-face encounter with the examinee, and specifically your physical examination of the examinee, and devote some of that time, in other words, steal some of that time, and devote it to answering the questions in the cover letters. Answering the questions in the cover letters. Now, answering the questions that are sent to you in the cover letters is required by law. It's CCR 35.51, 35.5C, Section 1 that describes this requirement. And I'm going to read this exactly to you. It says, the evaluator shall address all contested medical issues arising from all injuries reported on one or more claim forms prior to the date of the employee's appointment with the qualified evaluator that are issues within the evaluator's practice and areas of clinical competence. And here it comes. It says, the reporting evaluator shall attempt to address each question raised by each party in the issue cover letter sent to the evaluator. So by law, and many qualified medical evaluators don't realize this, but by law, the purpose of our evaluation is to be able to answer the questions raised by the parties in the cover letters. Sometimes qualified medical evaluators think that they want to do what they want to do with each and every evaluation, whereas the best qualified medical evaluators realize that the purpose of the evaluation is to be able to resolve disputed issues which are resolved by parties other than the qualified medical evaluator. In other words, the parties have to go through us as qualified medical evaluators to get answers to medical questions. And the questions that are medical that they need answers to are given to us in the cover letters. So the law requires that we as qualified medical evaluators address the questions in the cover letters. Now I want to tell you a story. I was once at a QME continuing education seminar, and a seminar was being conducted by a panel of experts up at the front of the conference room. And the panel of experts consisted of judges, applicant attorneys, defense attorneys. There were some qualified medical evaluators, a panel of experts. And the topic of cover letters came up. And the attorneys were reiterating this code in the labor code, the requirement for us as qualified medical evaluators to address the questions in the cover letters. And of course, the qualified medical evaluators in the audience raised their hands and explained to the parties their plight, the plight of the qualified medical evaluator. And the qualified medical evaluator said things like, well, you don't understand. Many times the cover letters that we get are boilerplate. Another one raised his hand and he says, the cover letters that I get all the time are the same. They're the same templated, non-customized cover letters. They're not specific to the examinee. They're generic. And the qualified medical evaluators were explaining to the panel of experts that you don't understand how we have it, how bad we have it with regards to the cover letters. And there came a pause among the group, and it seemed that all conversation on the topic had been exhausted when it came turn for one defense attorney to offer his opinion. And He put his head in his hands in an expression of dismay and anguish and angst. He put his head in his hands and he shook his head back and forth to great dramatic effect. And finally, he removed his hands from his face. He looked at the audience. He took a deep breath. And he said, "The cover letters that you get are the cover letters that you get. Would you please address the questions in the cover letters you get?" And his point was well noted. We as qualified medical evaluators address issues that we want to address. But it's the parties that resolve disputed issues. It's the parties that need us to give them the answers to their questions. They're their questions. They're the questions that they have regarding the evaluation for which they need answers. And they need the answers in the way that the questions are addressed. So the better you can answer the questions in the cover letters that you get, the better and more useful will your report be. The better and more useful will your report be. The less likely it will be that the parties will have to come back to you and request a supplemental report for which you may or may not get paid. So you can increase and improve the efficiency of your evaluation by taking the time to focus on the questions contained within the cover letters, even when you have to steal that time from other aspects of your evaluation that aren't so critical to the parties. See, our reports serve the parties. So the parts of our reports that best serve the parties are the sections in our report where we address the concerns of the parties. Okay? Now, that gives you some instruction as to how to focus your face-to-face evaluation and how to construct your report. Let's talk now about one of the biggest issues related to the new medical legal fee schedule, and that has to do with our review of records and the number of pages of medical records that we receive. Okay, so the next QME secret of success that I want to share with you has to do with one of the most controversial elements of the new medical legal fee schedule, and that has to do with your review of records and the number of pages of medical records that you receive for the evaluation. Now, the number of medical records that you receive for the evaluation is the main driver of the cost of the reimbursement and the amount that you can bill for your evaluation. The flat rate fee of each of the medical legal billing codes has contained within it reimbursement for a fixed number of medical records. So a initial comprehensive face-to-face evaluation includes your review of up to 200 pages of medical records. A re-evaluation includes up to 200 pages of medical records. A supplemental report includes up to 50 pages of medical records. So medical records and the number of pages are a central aspect of the new medical legal fee schedule. And I'll share with you several new revelations that we've discovered regarding this. Now, number one, in terms of getting the big picture of the medical records and your review of those records, it's important that you meet the requirements of what the law requires that we as physicians, as evaluators, include in our review of records. And there's 4 laws that govern the review of records. There's 2 labor codes, which is 4062.3D and 4628A, and we're going to review 4628A in just a moment. So there's 2 labor codes and 2 codes of regulation, 10606 and 41B2. So these laws describe and dictate what we as qualified medical evaluators need to include in our review of records. And I've included those for you here, and it's important that you review these for yourself. And what you're going to find is that each of these labor codes or codes of regulation contain within them, within the language, some verbs. And the verbs tell us what we're supposed to do. The verbs tell us what we're supposed to do. So you need to comply with the verbs. Now, in some of these codes, the verbs are duplicative. And in some of these, the verbs are unique. So it's important that you comply with the verbs, but no more. It's not necessary to do more than what is required by these 4 laws. So sometimes qualified medical evaluators, at least under the old medical legal fee schedule, in performing their review of records, would recapitulate the entirety of the medical record within their review of records. And the review of records basically contained every written word on the document that they were reviewing. They would recapitulate the entirety of the document. Well, that may have had some value under the old review of records, which was a complexity factor, certainly under the ML 103 and ML 104. But under the new medical legal fee schedule, there is no complexity factor for the review of records. So your review of records should comply with the requirements, but no more. Any information contained within your review of records that's superfluous, that doesn't add to or doesn't contribute to your opinions and conclusions, is simply superfluous and simply a waste of time. So I'm encouraging you to review these 4 laws and to comport and to compress your review of records into only what is required by these 4 laws. Number 2, it's important that you detail the number of pages in your review of records. And the records that you review include not only the medical records, but include any other records that you receive from one or more of the parties, including the cover letters. Many times cover letters can approach 6-7 pages. That you review applications for adjudications of claims. Any documents that you receive and review contribute to the number of pages of your review of records, and your number of pages may not always exactly coincide with the number of pages that are attested to by the party that provides you those records. So detail exactly the number of pages and describe in detail any discrepancy between your number of pages and the number of pages that the parties have attested to sending you. In your review of records, you want to include a physician declaration as to the number of pages that you did review. Include this right in your report, and a declaration could be something as simple as I, Becky Smith, MD, QME, declare, under penalty of perjury, that I reviewed 292 pages of records in connection with this evaluation period, and that's it. So include a physician declaration within the body of your review of records, right within the substance of your report. Okay? Now, I want to share with you something interesting that one of the parties sent to me recently regarding my review of records, and we'll discuss this in a little bit of detail. So with regards to the review of records, one of the labor codes that details what it is that our review of records must include is Labor Code 4628. And Labor Code 4628 has to do with a document that I received from one of the parties that I want to share with you. So let's review in brief some of the sections of Labor Code 4628. And I'll read exactly from the law here as it's written. It says, except as provided in subdivision C, and we're going to talk about subdivision C because that's the substance of what it is I want to share with you. So this is merely some background here. Except as provided in subdivision C, no person other than the physician who signs the report, except, for example, a nurse performing those functions routinely performed by a nurse, such as taking blood pressure, no person shall examine the injured employee or participate in the non-clerical preparation of the report, including all of the following. And number 2, it says reviewing and summarizing the prior medical records. So here, this is some of the verbs that I was referring to earlier. So Labor Code 4628 tells us that the doctor's review of medical records must involve the doctor's reviewing, that's a verb, the doctor must review and summarize the prior medical records. So at least according to 4628, the doctor must do 2 things with the prior medical records. He or she must review those, and he or she must summarize those. Now, some of the other labor codes that I shared with you and codes of regulation tell us what the summary should consist of and what we can limit our summary of the medical records to. But this gives us some idea as to what this particular labor code requires from us as the medical evaluators. Now, under Section C, referred to here, it says, except as provided in Subdivision C. So Subdivision C gives us the exception that all of these things must be done by the QME, him or herself. Must be done by the QME. The QME must review and summarize the medical records except as provided in Subdivision C. So let's go over Subdivision C. Subdivision C tells us if the initial outline of a patient's history, I should say comma, or the excerpting of prior medical records is not done by the physician, such as it's done by a third party, it's done by a secretary, it's done by a company that does review of records. It says the physician shall review the excerpts and the entire outline and shall make additional inquiries and examinations as are necessary and appropriate to identify and determine the relevant medical issues. Now, Section C applies to many, many qualified medical evaluators who have the review of records excerpted for them. And then the qualified medical evaluator reads the excerpt. So rather than reading 1,000 pages of medical records, the qualified medical evaluator can read an excerpt of perhaps 40 or 50 pages. I'm just making this up, but you get the concept that some other party condenses and summarizes and excerpts the prior medical records in order to maximize the efficiency of the actual qualified medical evaluator. Okay, so many of us do this. We use a third party to excerpt our prior medical records. Well, if the excerpt of the prior medical records is a condensed version of the medical records, how does that factor into the page count that the qualified medical evaluator is allowed to bill for under the new legal fee schedule? Say you as the qualified medical evaluator receive 1,000 pages of medical records that are then excerpted by another person down to, say, 20 pages. Do you as the qualified medical evaluator get to bill for 1,000 pages of medical records, or do you get to bill only for the 20 pages of the medical records that you actually reviewed? Well, one of the parties now exercising their incentive under the new medical legal fee schedule sees it in favor of themselves and is taking advantage of their interpretation of the new medical legal fee schedule by sending to the physician their own declaration of record review, for which they're demanding that the physician sign the Declaration of Record Review. And the one that I received recently, I'm going to read it exactly to you as it was sent to me. It says, I declare under penalty of perjury that pursuant to Labor Code Section 4628 and CCR 9793N, and we just read Labor Code Section 4628 that requires that the physician review and summarize. Review and summarize. And we'll talk about Exception C in just a minute. Exception C, which we just discussed. It says, I have personally reviewed blank number of pages of 8.5 by 11 single-sided document, chart, or paper, whether in physical or electronic form, records in connection with my examination of this patient. So I don't have any problem with this, and you can certainly take this declaration and include this declaration in yourself into your report. There is nothing in Section 9793N that requires you as a physician to sign any declaration from any party. But this particular party, in interpreting the new medical legal fee schedule to their own incentive, is using this form, has created this form, and is sending this form to us as qualified medical evaluators. This is consistent with their interpretation of their rights under the new medical legal fee schedule, but nowhere in the exact language of 9793 or 9795 is it required that we as qualified medical evaluators sign such a declaration. Well, the interesting part of this particular declaration that this party sent to me was the next section, which deals with Exception C of Labor Code Section 4628. And it says, I understand that if pursuant to Labor Code Section 4628C, if someone other than myself provided an outline or excerpt of the medical records for my review, the billing statement shall reflect only those pages that I personally reviewed, as well as any other 8.5 by 11 single-sided documents required to be reviewed as necessary and appropriate to identify and determine the relevant medical issues. So isn't this incredible? What this is saying is that the parties, the provisors of the medical records, are stating that if we send you 1,000 pages of medical records and each of those pages are not personally reviewed by you, in other words, they're excerpted by some other person besides you, you're only eligible and allowed to bill for the number of pages that you did personally review. And does this make sense? Is this fair? Is this appropriate? Well, we don't know. What we know is that this is this particular party's interpretation of the new medical legal fee schedule. There's nothing here that is described in the new medical legal fee schedule that reduces the doctor's ability to bill for the number of pages that they received compared to the number of pages that were personally reviewed. And further, there's nothing in any of the new language of the medical legal fee schedule that requires a physician to sign such a declaration, but this is a measure that's being undertaken by the parties as they begin to exercise their new incentive under the new medical legal fee schedule. And their new incentive, I'll just tell you, has to do with reducing the amount that qualified medical evaluators charge for their review of records. And I know this to be true because I recently received a phone call from a legal secretary at a defense attorney law office, and she was calling. Her job is to handle the review of records in her department at the law firm. And she was calling my office to see if we would be willing to receive medical records on a CD disc or an electronic form, or how did we best want to receive those medical records. And by chance, I myself answered the phone. And so we started talking about medical records, and I laughingly said to her, I said, well, we can talk frankly about the medical records because I'm on the fee schedule committee. I was at the fee schedule committee meetings, and I know all about the review of records because we talked about it at great length, and we laughed about it, and she disclosed to me that her job at the law firm for which she was working on as we speak is to reduce the number of pages of medical records that are sent to the medical evaluators. So, and that makes perfect sense. The incentive of the payers is to reduce the amount of medical records for which we as qualified medical evaluators can bill for. And this here is one step in that direction of the parties attempting to exercise their incentive under the new medical legal fee schedule. So this is something that we can anticipate, and this is something that is as yet undetermined or unresolved as to how our billing should comport in relationship to the number of pages of medical records that we receive compared to the number of pages of medical records that we personally reviewed. But as such, at this point in time, there's nothing in law that requires us as qualified medical evaluators to sign such a declaration. Okay, so the final secret of success that I want to share with you in keeping with our overriding philosophy that time is of the essence, and if time is of the essence, we must always focus on the big picture of the case. With that as our philosophy, I believe it now more than ever necessary for us as qualified medical evaluators to keep up on our continuing education as qualified medical evaluators. And some specific suggestions that I have for you is that you become a maverick on the AMA guides, not only in the chapters related to your specialty, but also in the entirety of the philosophy of the AMA guides. Chapters 1 and Chapters 2 of the AMA guides provide critical philosophy that will help you in arriving at accurate opinions and conclusions. And the more familiar you are with the AMA guides, the more quickly and efficiently you can get to the bottom line determination in your report. Okay, this is perhaps a subheading under the larger topic that we discussed earlier in dealing with the recurring theme. So in the evaluations that you're called upon to perform, for each body part, there's a limited number, a finite number of impairments for which the examinee will qualify for. And the more familiar you are with the impairments related to each body part, the better you can target your face-to-face evaluation and specifically your physical examination with the examinee. Number 2 is to memorize and become extremely familiar with the 2016 Physician's Guide. You know, there's some concepts in the 2000 Physician's Guide that you can rely on when the going gets tough and you're faced with difficult decisions. The 2016 Physician's Guide provides fabulous philosophy and fabulous background information for us as qualified medical evaluators. And I'll share with you a quick story. I was talking with an evaluator yesterday, and he was being challenged on the opinions and conclusions in his initial evaluation, and he was being asked to provide a supplemental report to explain his position. And we went to the 2016 Physician's Guide, and we pulled up some concepts there right out of the Physician's Guide that exactly resolved his conundrum for him and allowed him to produce a supplemental report that supported the opinions and conclusions that he offered initially. So the 2016 Physician's Guide is an invaluable resource for us as qualified medical evaluators. And I myself routinely read and reread the 2016 Physician's Guide, and I always discover new ideas within it, probably because each time that I do read the 2016 Physician's Guide, I read it with new eyes. So I encourage you to obtain and review the 2016 Physician's Guide very frequently. Finally, it's essential that you become fluent with case law. And there are some cases that are more important for us as qualified medical evaluators than others. So certainly you should be familiar with some of the precedential cases, such as Alvarez and Guzman, such as the Kite case, such as the Cannon case, such as the Benson case related to apportionment. So there are some critical precedential cases that you need to be fluent with, because those themes recur over and over and over and over again. But also, the more fluent you are and the more often you read cases, the more familiar you become with not only the issues, but also with the language that's used to resolve these disputes. And the more you can comport the language in your reports to comport with the language that's used in the resolving of these cases, the better able will your reports be in resolving the cases. You know, a lot of being a qualified medical evaluator has to do, a successful qualified medical evaluator has to do with learning a foreign language. Learning the language of the parties and not speaking so much your language, the doctor language, but converting your language into the other party's language that can be used at the court level in resolving these disputed issues. So I encourage you to review as many cases as you can possibly get your hands on, because it will help you immeasurably in the efficiency of your very next evaluation. So doctors, I hope these ideas and these secrets of success will help you. You know, the new medical legal fee schedule is here to stay. It's upon us now, and it is the system that we're probably going to be using for probably the next decade, if not 2 decades. So there are better ways than others to use the new medical legal fee schedule, and now more than ever, time is of the essence. And I hope these ideas that I shared with you in these several series of discussions will be of great use to you now and into the future as you continue with your career. So this is Dr. Perry Carpenter. I want to thank you for taking the time to join me on this discussion. I look forward to being with you on future discussions as well. And for now, I'm wishing you best of success in your career as a qualified medical evaluator.